Grace and peace. Good morning, good morning, good morning. This is Dear World Christian. You saw the thumbnail, you saw the title. You know what we're about to do. We have yet another YSL update. So we had planned today actually to jump on and follow along with the motion hearing that Judge Whitaker is going to be facilitating, the oral arguments that are going to be going on today. And that looks like it's going to be super interesting. It's in about 27 minutes. However, in YSL never lets you down fashion, last night or yesterday, or let me double check exactly when, there have been some new motions that have been filed. Motions to recuse some other people. So we got rid of Glanville. And now there's another option. So we're going to look at it as well. We're going to jump over here very quickly. Hold on one second. Okay. Hold on one hot second. So I'm just doing a real quick mic check, make sure everything's good. We're going to go through some of these motions and prayerfully we'll get done with the motions in time for Judge Whitaker to start her debut. It's my niece, my cousin, my sister. I don't know what. So she's related to me somehow, I'm sure. All right. Let's send that off. Shout out to everybody who's stopping by again. I know we were planned to start at 11:15, but I was like, I could go through this motion. So let us go, Jason. What is this motion that you're referring to? I'm glad you asked. All right. In the Superior Court of Fulton County, the state of Georgia versus Jeffrey Young Slime Williams. And I'm just enjoying seeing Whitaker on the indictment. I think that's hilarious. So this is Judge Whitaker. And what is this? This is the motion to disqualify lawyers Love and Hilton. At this stage of the game, I think Brian Steele is doing them a solid. He's like, look, y'all, I'm about to get you kicked off of here. I would probably just take it. If I were them, I'd be like, yo, could you, I'll help you write it. Just get me off it. I'm so sick of this. Like I'm willing to help you write it to get me kicked off. So therefore, I don't have to keep worrying about this foolishness because it's a dumpster fire. So Brian is going to put them on the sticks. Here it comes. Comes now, Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to disqualify lawyers Love and Hilton in the above referenced case. In support of this motion, Mr. Williams shows as follows. At this point in the game, I'm enjoying reading these. These are becoming some must reads now. I'm enjoying them because the way Brian writes is so comical to me. And by the way, I still have that video explaining why Brian Steele writes like he does. And I still haven't done it yet. Okay. Because we haven't had any opportunity to stop. That's why. So it's not because I don't want to tell you, but let's continue. Mr. Williams is innocent of all crimes in the above reference indictment. Full stop. Wow. He's not pulling back any punches. He's letting you know right now, you got an innocent man in your midst. Let's keep going. As previously asserted, lawyer Love and lawyer Hilton have made themselves critical witnesses in this case, including, but not limited to, when lawyer Love engaged in text messages with witness Aurelia Bennett, and lawyer Hilton, and lawyer Glanville communicated with sworn witness Mr. Kenneth Copeland in a critical stage of Mr. Williams' trial during the now infamous June 10th. It's infamous. We got the outlaw Josie Wales. We got the Watergate. And now we have the infamous ex parte of June 10th. Come on, man. I love it. Wholly improper ex parte in chambers meeting, the sacrosanct. I'm sorry, Brian Steele is very serious. This is a very serious situation that these men's lives are in jeopardy. But I'm going to tell you right now, they got the right attorney. They got the right attorney because Brian Steele is playing no games. The names are going to be named, okay? Let's keep going. Undersigned counsel has the duty to cross-examine Mr. Copeland, Lawyer Love, Lawyer Hilton, and Judge Glanville on all the facets of this secret strategy session pursuant to, okay, I got to stop right there. This guy called it a secret strategy session. Not just an ex parte, not just there was a meeting in the ladies' room. There was smoking in the boys' room. No, this is a strategy session. Yo, I'm only laughing because Brian Steele is the absolute unequivocal GOAT. I don't know what Brian Steele is getting paid. All I know is I'm praying if I ever need a lawyer that I make enough money that I can afford Brian Steele. That's all I'm saying. Otherwise, I don't want to do no crimes. I'm not doing no crimes because I cannot afford Brian Steele because I need Brian Steele. I mean, I don't care. This guy is the best. He called it a strategy session, not an ex parte, not just a meeting, not just a conversation in Star Chambers. No, a strategy session. Brian Steele is so petty. Let me tell you. And I am here for it. I love Brian Steele. Dear Brian Steele, you are my guy. You are my kind of guy. And Brian Steele's probably looking around like, what the heck are you talking about, Jason? I'm just writing to be writing. But let me tell you, this stuff is hilarious. But let's keep going. Confirmation clause, and am I right? Okay, yeah. Confirmation clause. Move this out the way. There's this confirmation clause. Right pursuant to the defense. This is in my way. Defense. Why is this in my way? I have a status bar from my struggle streaming eCam that you can't see. All right. Confirmation clause, right to present a defense, 6th and 4th Amendment, right to effective assistance of counsel, due process, right to a fair trial, as well as a fair tribunal on behalf of Mr. Williams under both the Georgia Constitution and the United States Constitution. This will mandate that Mr. Copeland be cross-examined before the jury about his meetings and conversations with Lawyer Love, Lawyer Hilton, and Judge Glanville. This essential questioning injects the veracity and the credibility of Lawyers Love and Hilton and Judge Glanville. Undersigned counsel will also examine Lawyer Love, Lawyer Hilton, and Judge Glanville as to why they knowingly made false and misleading assertions to Mr. Copeland about the alleged disloyalty of Mr. Copeland's lawyer and provide legally inaccurate information, Mr. Copeland, in order to persuade Mr. Copeland to testify against Mr. Williams. Why did y'all have this strategy session and give wrong information to Woody? You besmirched Jonathan Melnick's name, and you gave him bad information. I know I'm joking and saying that Judge Whitaker is related to me. She's not related to me. I think you can see there's no family resemblance. However, if she's a Whitaker with one T, she's throwing this thing out before the end of the day. She's throwing this thing out before she goes to go get lunch today. I'm telling you. If she's remotely related to me by any way, by hook or by crook, this thing is in the wind before she orders her iced caramel macchiato over at Starbucks today. Because I'm telling you, this is garbage. And Brian Steele is having none of it. All right, let's keep going. And I'm just going to read over it, add a little bit of color commentary. We're almost done. It's one more page. And then actually at 11:30, again, if she's a Whitaker, she's starting at 11:29. So let's keep it going. Based upon their own deliberate and intentional concealed misconduct, Judge Glanville's lawyers. Oh. Okay, no, I'm sorry. I thought he was saying that the lawyers belong to Judge Glanville. I'm sorry. Judge Glanville's, Lawyer Hilton's, and Lawyer Love's credibility and acts are now at the center of Mr. Williams' trial. My goodness, in the morning. These lawyers must be removed and disqualified from further participation in the case. I'm going to stop right there. I think Actually, especially when you're looking at the disqualification case as relates to Fulton County disqualification and the election interference, I'm wondering, does that mean all of Fulton County? Because I can see Brian Steele, and I might be wrong. Again, I'm a pre-K law student. I know nothing. I could see Brian Steele saying that all Fulton County should be disqualified because of this. Now, I'm not saying he's going to say that, and I'm definitely not saying that he is saying that. All I'm saying is I can see that being the next step. Like the whole office needs to get thrown out. So that would require, oh my gosh. I don't think that's what he's doing, but I can see if it happened, let me say it like this, I will not be surprised. If she says Love and AD have to get out, and then I can see Brian Steele next motion be to remove all of Fulton County from it because the whole thing is corrupt. I can see it. I don't know if that's what he's doing. I don't know if that's right. I don't know if that's legal. I don't know if that's the right MO, but I can see that being the next logical step if he doesn't do it already. Let's keep going. These lawyers must be removed and disqualified from their further participation in the case to save as witnesses. Wow. He's telling you, like, I'm about to tap y'all as witnesses, y'all. I'm about to make your day really, really mess your day up pretty bad. That is wild. Let me see real quick. Sorry about that. Yeah, I think this is going to be wild. Okay, so he gives a lot of cases right there. Let's jump down to number 5. During the jury charge, it is expected that the honorable court will be asked to instruct the jury as suggested in pattern jury instruction 1.7.10 as follows. Lord have mercy. What?
Live chat. I got a job.
She got a job. Let's go. Live chat.
They're asking me like when I can come in for my uniform fitting.
Well, you have a car. Go.
Not
go,
today. It's
go
like
get
next
fitted.
week.
Go get fitted Monday.
Or she
go on Sunday. Go Sunday.
No, they were like Thursday or Wednesday.
Okay. Oh gosh, now it's just like a meeting in here.
What's up, chat? Hi.
Okay, what are y'all doing? I'm doing important things here, people. I'm talking about important things. I'm adding value
to the discourse.
I'm adding to the discourse. That's what I'm doing.
I'm adding to the discourse.
I'm a discourse
actually,
you.
I'm adding to the discourse.
That's
a nice hat. Is that
thank
something
you.
You got from the game?
Yes, it is.
Totally
really
an
cute.
important thing.
Totally.
So important.
So important.
I love you.
Oh, see, they're all saying congratulations because I got a job. Thank you guys.
Good job on getting a job.
Wait.
Oh, yeah, do that. Does it work?
Good job. She got so happy.
Wait.
Yeah.
Will they open?
Yeah, those are balloons.
What will I be doing? I'll be working at the drive-thru of Chick-fil-A.
Okay, so clearly, has my show been derailed?
Yeah.
By y'all? Okay.
I've been working, I'm going to be working at the drive-thru at Chick-fil-A, inside or outside, which means when it gets cold, I get that super fire windbreaker that they have.
I need you to work on saying my pleasure.
My pleasure.
Okay, Trina. Okay, let's see. Here, look in the camera. Look in the camera so everybody can see. Trina, I would like you to go empty out the dishwasher.
Sorry, we don't offer this.
Can't offer that service today.
Oh, Taylor, don't worry. I want you to go put those clothes. I want you to go start those clothes in the dryer.
I don't work at Chick-fil-A, silly little guy.
Please go away, you little.
Guys, I'm not going to front. I feel like we have more fans than you.
Yeah.
Yeah, you're probably right. You're probably right.
We're going to the mall. It's telling me to take the highway.
The highway? I would like you to go up Cobb Parkway, but okay.
Okay.
All right. Travel
fine.
well.
Bye, Daddy. Love
Bye,
you.
babies.
Goodbye, chat.
Bye, Chad.
Shut the door. I don't even know what we were talking about. How do they become such? If you're a parent, you've seen this experience where they start out as little tiny people, and then next thing you know, they're going to the mall. Okay, let's get this done because I don't want to miss out. Because my niece is going to probably start court soon. Oh, here we go. Right, we were right here. During the jury charge, because he already saying he wants a jury trial. He's gonna mess these people's days all the way up. During the jury charge, it is expected that the honorable court will be asked to instruct the jury, as suggested in pattern jury instructions here. The court has no interest in this case by no ruling or comment that this court has made during the progress of this trial. Has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Undersigned counsel requires this above testimony by lawyers Love and lawyers Hilton and Judge Glanville in order to have a deliberating jury consider whether Judge Glanville was in fact biased for the prosecution, and that this jury instruction is not applicable prior to July 15th, 2024, the day Mr. Williams' motion to recuse Judge Glanville was granted. Wherefore, Mr. Williams respectfully requests a hearing on the motion and the conclusion of the same. Ask the honorable court to grant the above requested relief on the 18th day of July. Wow. Y'all, I am not a Brian Steele stan or something like that, but let me tell you right now, Brian Steele knows exactly what he's doing. He understands the assignment completely and totally. This is amazing. Because what he's doing, in my understanding, and again, I'm a pre-K law student, so I know nothing. All right. But what Brian Steele is doing is not only separating Love and Hilton and Glanville from the trial, but he's basically, in my understanding, he is tacitly threatening them that y'all are about to be on this witness stand. You all are about to become witness number 301, 302, 303. You're not going to be Judge Glanville. You're not going to have the honorable role of being ADA Love. You are going to be regular old witness man and woman in that witness box, the same box that Woody was in, the same box that Bean was in, same box that your run-of-the-mill criminal was in, and you're going to be in that box. And I am going to drill you hard. I mean, that's what I'm understanding. Now, again, I could be wrong because, again, I'm a pre-K law student. I don't even know what I'm talking about. But I can tell you right now, it looks like tacitly, in my understanding, that Brian Steele is saying, look, I'm about to bring this noise. You are not ready for what I'm about to do. I don't see it any other way. I don't see it any other way than Brian Steele is saying, look, it's about to get real ugly up in here. And I'm here for it. I am here for it. Now, today, I believe, I don't think, here on the site, it says day 101. I don't think this is a true trial day. They're calling it day 101. That's wild, because on day 100, to celebrate day 100, the trial went completely off the rails. But I believe they are going to, let me make sure I like this. I always like law and crime. I believe they're just hearing for whether or not to offer bond, as well as I think they're also arguing about the removal of Love and Hilton. All I can tell you is this thing is amazing. I'm going to start calling this the DWC 24-hour news network, brought to you in part by YSL. Okay, because it's crazy. I don't know any other way to say this. This is crazy. And to live here in Atlanta, knowing that Fulton County Courthouse is just down the street around the corner a piece from me, I'm like, that is crazy that this is going on in 4K right here in my city. And there's so many people that have been checking this out. We've had people from Germany and the Philippines, South Africa interacting with us. That's crazy to me. That is bananas that this has garnered so much interest, dare I say internationally, that people have been checking this out from Australia. People, I got friends in Alaska. I've talked to somebody in every state. That is crazy to me. And it's just because of this little trial here. And we're watching it be so poorly executed, so poorly prosecuted, that it's going to fall apart on some very basic things like, why in the world were you having a conversation with a witness? I have no idea why that's so funny to me, and so no idea why somebody did that. But let us keep this going. Let me real quick shout out to everybody that stopped by. Thank you so much for being a part of the best live chat on the planet. Let me give you those instructions right there. Thank you so much for supporting the channel. Thank you so much for dropping by. And of course, to be a part of the best live chat on the planet, on this side of Pluto, all you got to do is just hit the like button and say what's up. So real quick, what's going on? Q is in the building. Good to see you, sister. Thank you so much for stopping by. Tom Ray in the house. Good to see you, sir. Always make sure you like the button. You hit that like button on your way in. Cheryl, good to see you. Judge Glanville should be in jail and Young Thug should be out. I'm not going to throw Glanville in jail, but I do believe Judge Glanville needs to be held accountable for this. Hands down, unequivocally, no problem with that at all. Should you have an interrogatory for the pre-K law student, please preface your question. If you have any questions for me, just mark them as question. Absolutely. Hey, Miss Mandy. Good to see you. Thank you so much. A fantastic supporter of the channel. Miss Mandy Reacts. Thank you so much. All right. Somebody's got the popcorn, Steve. Don't worry about it. We'll pass it around. Somebody's going to pass it around. Good to see you retired. Good to see you this fine morning. As the Peach Rots. Oh, I didn't do As the Peach Rots. I got a few minutes. Hold on. I didn't even have it queued up. Man, I forgot. We might have to do like a 25-hour news network one now. Here, let me get you out of the way here. Just in case you didn't know what we're doing, ladies and gentlemen.
Welcome back to Season 4 of As the Peach Rots. In this suspenseful 4th season, we marinate the feeder of Georgia's political elite in the tangy vinegar of accountability. In a state where the odor of mendacity toxifies the air, our perspicacious team of chatroom investigators is on a mission to peel back the layers of deceit and uncover the truth. From backroom deals to embezzlement scandals, no stone is left unturned in our pursuit of justice. But as tensions rise and alliances shift, who can be trusted in the Peach State? Join us for a season ripe with virality, where even the fruit isn't safe from corruption, because sometimes the juiciest scandals are right under your nose.
Thank you so much. And real quick, everybody, you may have noticed, like, man, dear world Christian, you kind of sound like you know what you're talking about. You kind of sound like you're getting a little bit more educated in this pre-K law class. I want to shout out to the Black law student has been helping me out significantly behind the scenes. Shout out to the Black law student. We're going to do TBLS in the chat. Can y'all type TBLS in the chat and say thanks so much for all the help? He's been helping me out a whole lot. Hopefully soon we'll be able to have him come on the channel. We got some good things to talk about. So thank you so much to the Black law student. Thank you so much. Let's keep this going. What we got? Sorry, I missed. Once I typed that, it threw my thing off. All right. What is going on? Q is in the building, okay? Make sure you hit like and subscribe. I agree with you. Absolutely. Shara's here. Hey, Shara. There she goes. Hey, Miss Covey, how are you? Good to see you, friend. Oh, wait. Q says, I'm trying to listen to 3 things, including jury instructions in my witchcraft trial. Girl, you watch entirely too many crime shows. You are funny with these crime shows. What is going on? Oh, they're firing home. My niece is not playing games.
I think y'all had at one point like placards that you could sit in front of you. We'll find them if they're, I mean, it's fine for now, but
Wow.
And I know you, Mr. Short, but
drop a 1 in the chat you can hear.
Good morning, Judge. Good morning.
All right, so that's Weinstein right there. That's Shard. I forgot my man with the great beard right there. I forgot his name.
Yeah, I mean, we don't have to do it right now. I'm just saying right as we move,
there's Brian
for the first couple of weeks at least, if y'all don't mind doing that for me. So, introductions.
Judge, Max Shard, I represent Shannon Stillwell. My co-counsel is Mr. David Botts, who is also here, and because it's next to me, this is Shaquille Kokomo. He has been working on the audio visual on behalf of some of the clients, including Mr. Stillwell, so he's been a big part of this case as well.
All right.
Shaquille Kokomo.
Are you an attorney or paralegal?
He's going to be a law school student.
Okay.
Let's hear it for law students. Okay.
Right now.
Fabulous. Good luck to you.
Law
All
students in the
Thank you.
building. Let's hear it.
Good morning, Judge.
Good morning.
Carrington Matthews Sr. here. I represent Marquavius Healy in this case. I also have, also representing Mr. Marquavius Healy is my son, Carrington Matthews Jr., who is not here today, and also attorney Teresa Mahfoud. They're all from my office, and we represent Marquavius.
Okay. And I had both of your names. I don't know if I have Miss Mahfoud's. Has she entered an appearance?
Yes, Madam Chair.
Okay. All right. Well, we can update that. Okay. Thank you.
You're welcome, Your Honor. Thank you.
Hey, Mr. Butts.
David Butts, Shannon Stillwell. Good morning, Your Honor. Doug Weinstein. I represent Mr. Diamante Kendrick,
Okay.
along with my co-counsel Jay Apt, who's ill today, and Katie Hegarty, who's on leave right now.
Okay. All right. Hopefully, Mr. Apt will be feeling better
Thank you.
soon. You can pass that along to him.
I'll do that.
All right.
Good morning, Your Honor.
Morning.
I am Brian Steele, and I have the honor of representing Mr. Jeffrey Williams, along with the Honorable Keith Adams. Sitting next to Mr. Adams is a law student. He's a rising second year, John Marshall Law School. His name is Griffin Lail, Griffin Lail, if it's okay for him to sit with us. It would be appreciated. If not, he will obviously.
Is he sworn in under like the Third Year Practice Act or?
No.
All right. So I guess he can just act as a paralegal for now. Okay. Good to have you.
Good morning, Your Honor.
Good morning.
Leah Olasky here for Mr. Rodelis Ryan. I am the second chair to Ms. Angela D. Williams, who is ill today. I think she's expecting a Zoom link.
She should be on Zoom, and I guess I should get on the Zoom as well. Give me a second to do that. Okay.
I haven't seen the judge yet. What she look like?
All right. Miss Rosser or Miss Persfield, will I find a Zoom link on my calendar or? Okay. Give me a second to get on there. Well.
Yo, they started on real time. They were not playing games. No comfort break. Look at Brian.
We came and tested everything yesterday, but of course the computer is not wanting to cooperate.
Glanville locked her out. Changed the password.
Can I just go through Zoom? Trying to find my...
I should have muted us. Okay, so it is wild that they're in Glanville's courtroom. Look at Brian. Look, Brian knows we about to shut this whole party down. Brian said, I'm about to tear this whole club up. He just enjoyed it. He's like, bruh, so where we going to go for dinner tonight? Because I'm about to totally mess this whole thing up. I don't know, man. What you think about Maggiano's? I don't like Mahjong. I was like, nah, I'm good. How about chops? Bones? Yeah, I'm good with bones. We can go celebrate for sure. Yeah, that's what's up. Yeah, because I'm about to tear this whole club up. I got 9 motions. I'm about to email right now. Yeah, so we about to mess this whole club up, and we're gonna listen to some. We're gonna listen to some. I like that for sure. That's what's up, my guy. Yeah.
Just not by, I'm not seeing her on the screen.
Oh, Your Honor, I'm here.
Okay, you're just not on video with us?
Right, but I'm here.
Okay, all right, well, good to have you. Hope you feel better. If you might be sick as well, I think. Okay.
Good morning, Judge.
Good morning.
Cole Westmoreland, Warren Gardner, on behalf of Marcus Nichols. And we have one additional paralegal, not paralegal, intern, who's not here this morning. If necessary, we'll introduce you to him at our next.
Okay, that sounds fine. All right, so a couple of things that we need to try to figure out from the outset.
Where's Weaver?
What is pending that I need to make a ruling on, and what our schedule is going to be like moving forward. I know there are already a couple of weeks that the jury has been sort of told you'll be excused for this week, so I will honor that. But I need for us to try to be efficient with the jury's time. So whatever we all need to get sorted out in the interim before we bring them back, as much as we can do, I'd like to do that so that we can minimize the times when they're here, but we have to send them to the jury room to figure out things that we could have figured out before. And I know sometimes that is going to be unavoidable, but to the extent we can avoid it, I'd like for us to talk to each other beforehand, give each other a heads up about what is going to be coming in or what we think might be an issue, and deal with it without the, wasting the jury's time, basically. So Mr. Steele, on behalf of Mr. Williams, sent me yesterday a list of what he believes to be pending motions that still need a ruling. And I think I have one that I know of from Mr. Huey, and I'm just going to kind of hear from each party as to what, as the state as well, as to what y'all believe is pending that we need to get heard. And since I've already got Mr. Williams' motions written down, I'm just going to make sure, Mr. Steele, that I've got all of the ones that you believe to be pending. So I saw in your email a July 8th and a July 9th motion to recuse both Judge Glanville and Judge Krause, which I'm obviously, we're not going to do anything substantive here today. I'm just going to make sure I know what y'all believe to be pending. A July 10th motion entitled for a fair trial that is essentially to find out about whether there have been any other ex partes. A July 1st motion that's kind of a proffer about something that happened with a jail call, evidence that's already been taken care of. And I mean, I'll look back into that. But a July 18th motion to disqualify two of the prosecutors. A July 10th motion asking, I guess, prospectively for a fresh look maybe at 24-8-801. And then you had also provided an amended witness list and a notice of filing. Are there any other pending motions for Mr. Williams that I didn't include?
It's not a motion that filed. May I address that just for your edit?
Sure.
Okay.
And are you going to file it? You're just giving me a preview, or?
I could file it.
Okay.
I'll do whatever this honorable court desires.
This honorable court.
So I just want to bring to the court's attention to be, fair to the court. May I approach, Your Honor?
Yes. And it may be easiest to just hand it to Ms. Pursfield. And y'all, It's on my mind right now. Before we all leave here today, I want to make sure that my staff has cell numbers for everybody. Okay. All right.
So I've handed this honorable court's co-worker and the state 2 cases, PROPST versus Morgan, MORGAN, and it's 288 Georgia, 862, 708 Southeast 2D, 211. And if you look at page 2 of the copy of the case that I've handed to this honorable court and the state, on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes?
Was there a written order?
He did file a written order.
June the 14th.
Okay.
2 days later.
All right.
And that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted. Judge Krause, in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added to the list, but I appreciate that.
I'll file it today. Can I add one other thing just for your knowledge? But
sure.
If it's something that's more than a status, then I will withdraw it.
Yeah, and I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
Understood. I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away, and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name's Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the motions.
Great. Okay. For Mr. Huey, I have got a renewed motion for bond. Is there anything else for? I don't even know which party I'm looking at yet. But
again, senior for Mr. Marquez Huey. That is the only motion that I've at this point.
All right. Yes, thank you. Okay, so for Mr.
So, Your Honor, the way that we had been operating under this case, under the Honorable Judge Glanville was.
Oh, he called him Honorable.
Yes, sir. Your Honor, the way that we had been operating under Judge Glanville was there was a thing we named the Harvey Rule, which assumed that all were in agreement in opting into a motion unless we specifically opted out of the motion. So
everybody's joined on everything.
Appeal has filed a number of motions that we opt into.
Okay.
And Your Honor, I'll also just point out, there's also the gentleman who's on the stand right now. I think that we need to have a hearing regarding the admissibility of his testimony. I too, I'm not looking at Mr. Steele's motion, but I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand and what he said.
Okay.
And additionally, after Mr. Weinstein's recusal motion, we spent a significant amount of time going back and forth about prior statements and redacting prior statements. And I believe that
prior statements of Mr. Copeland. Okay.
We would have to go through that process again because that was done after the Mr. Weinstein's recusal motion. So we probably need to relitigate that as well. Of course, if it doesn't fall under a hearsay exception, then we wouldn't have to do that. But
okay.
I don't think Love and them are happy. Love is not happy.
And with regard to the question of the admissibility of Copeland's statements under the co-conspirator rule, is there a pending motion or was there an oral motion? Has there been a ruling?
There was a ruling.
Okay.
I don't recall if it's been reduced to writing. I'm going to assume it was. But you know, we've litigated a recusal motion. We've talked about the appearance of impropriety at this point, and from our stance, we need to relitigate.
What happened? What happened? Okay, some reason or other, something. Hope it's not me. I don't know what happened. But a lot of people are commenting that they feel like Love does not look happy and they're going to start passing.
But just to educate.
But is that what you're saying should be reconsidered? Okay. All right. All right. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that.
Just all the rulings on
Mr. Copeland. Okay. All right. All right. And let's see, for Mr. Ryan, and I understand everybody's basically joined in on everything we've already talked about. Is there anything that's individual or in particular to your client that I need to think about?
Yes, Your Honor. And hopefully the state will correct me if I don't have it correctly. But some of what specific evidence the state plans on using witness has been specified somewhat on a rolling basis.
Okay.
I'm going to give an example. In Mr. Ryan's case, there are 15 recorded interviews.
Mm-hmm.
The state is not necessarily going to offer all 15. Within the ones they might want to offer, there are parts which are inadmissible. Everyone would agree they're inadmissible, but the state has not had a chance to sit down and specifically say, we want these statements, and here's what needs to be redacted, and go back and forth on that. So we've not crossed that bridge yet, Mr. Ryan. When we do, you'll have motions of that nature.
Okay, so I'm going to try, and we can maybe get to that in a minute, but I would rather everything that should have been a motion in limine get sorted out. I don't care if we're 2 months from that testimony. But,
that's absolutely fine, Judge.
Yeah.
Describe it on a rolling basis.
Yeah, well, to the extent we can stop that, we're going to try to get everything done beforehand, but we'll see. We'll see. All right, thank you. And then who else have I still not heard from? Mr. I will, y'all, in a couple of weeks, I'll know all of this, but I just honestly have not been following this case up until now. So, Mr. Harvey, for Mr. Nichols. And I may need you to yell.
I'm sorry.
Oh my gosh.
Yes.
Per the rule we've been operating under, we're all in on everyone else's motions, barring a on the record opt out.
Okay.
So we're in on everything because we have not opted out as of this point on any of those motions.
Okay.
There may be, I to be honest with the court, I wanted to see where we were today, what our plan was. There may be some additional motions that would be filed on behalf of Mr. Nichols and perhaps other defendants. If we're going to view this as sort of a logistical status conference, based upon prior proceedings, we've mentioned certain things. We've mentioned certain cases about what may or may not be valid or evidence post motion to recuse. There may be some additional motions that need to be filed. So I would ask that on behalf of Mr. Nichols, that not only we're opting in and we need to now think about whether or not there's going to be any specific opt out, but to give us some time frame to file any additional motions based upon the unusual proceedings and circumstances in this case moving forward.
All right, so I'm not going to be able to give you a blanket, hey, you get X amount of days to file whatever you want here, because I don't know what it is that you might be contemplating. And frankly, there have been, at least a week and a half that's gone by since whatever the ex parte was that caused all of this. It may be that it's appropriate for another motion to be filed and be considered. It may not be. I'll kind of have to wait and see sort of what it is and why it is only now that it is going to be filed. So I just can't give you an answer on that before I know what it is. But I mean, I'm certainly not precluding anybody from filing. I just don't know if it's something that could have been filed 10 months ago, then I probably don't want to hear it now.
No, I think these circumstances are unique, clearly. So it presents unique opportunities to now move the court now that we have a court. I just
so why don't I just say that if you are contemplating anything, contemplate it
quietly.
Quickly, and get it filed
5 business days?
Before the end of next week, because, and I want us to all look at a calendar in a few minutes, but, the jury has already been given the week of July 29th off, so they won't be back before August 5th, really. So I would like for us to if we're going to be moving forward with this case, be able to move forward with it and have all of whatever this is going to be out of the way before then. So if you can honestly, because I would also like a response from the state on anything that gets filed. So if y'all can, given that you've had already, you know, what, a week and a half since whatever went down. I don't know the exact dates of everything yet, but you don't really need 5 more days to think about it. I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but that is what it is.
Shout out to y'all.
And then I want responses from the state by that Friday, the 26th. Okay? Which does not mean I'm inviting them. It just means if there are some necessary ones that we need to think about it. Obviously, I'd like y'all to get briefed by both sides. And then we'll probably spend the week of the 29th we'll all be here without the jury trying to get as much done as possible, I think. Okay?
And that may answer my next question. I know that on behalf of myself, and I know various other co-counsel, I mean, as soon as the words "we're in recess" were uttered, I have emails, specialists at trials. I mean, I am inundated by other both federal judges and Superior Court judges. I am asking for protection, and I would assume that co-counsel would join in this protection so that I can say to these other judges, I am on trial, I'm required to be participating in this court, and you cannot set me for trial in another court because I'm on trial. Can we get that protection from the court?
Yes, you shouldn't even need that because we are in the middle of a trial. I don't care whether the judge has changed or not. This trial is ongoing. But yes, to the extent that any judge calls at my chambers, yes, I will tell them, sorry, you can't have Mr. Harvey right now. I've got him.
I want to make those representations in conflict letters. I want to make sure that I'm doing that properly.
Yeah. Now, if there is, because I have been until recently one of the people trying to get a hold of all of y'all for other cases. So if we decide we're taking a 2-week vacation in August, which we won't be, but you know, hypothetically speaking, and y'all aren't in here with me litigating something, then I'm probably going to say you're available, not for a trial, but for, you know, a 1-day hearing or something.
Yes. I don't mind the 1-day hearing. I do mind going to trial when
Sure.
I'm on trial.
Yes.
So with that,
y'all are all protected from being expected to be in trial anywhere else until the completion, however it completes, of this trial.
Thank you.
All right.
Your Honor, Doug Weinstein for Mr. Kendrick. We have no pending motions other than what has already been stated by our defendant's counsel that we all join in. We will be filing motions before Tuesday, but we have no pending motions. And you said we are going to discuss calendar moving forward? Yes.
Okay,
I have some comments with regard to that.
Okay. All right. Turning to the state. Are there pending motions by the state that need
here she
ruling?
comes. She's got a skirt on.
Thank you, Your Honor. There are, and we will have to the court before Tuesday of next week, as the court has made a deadline. There are responses to recent filings by some of the defendants that the state anticipates it will be making. And there are 2 anticipated motions in limine that we will have filed by Tuesday.
Okay.
Based on the court's earlier instruction today, there were matters that are more appropriately placed within a motion that we will have to the court by Tuesday as well. There are, and we will identify all of the ones that we believe exist. There are outstanding, there are rulings that have been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list as well. Thank you.
Of course. And we also intend to address, we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, all of the exhibits that have been tendered, ruled on, and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that, or if the court will permit us or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want it to be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
I would have preferred that the court just order that each of us present to the other the exhibit list that we have, to the extent that they do exist, and that we then endeavor to iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not been admitted.
Okay.
So we are asking for a date from the court.
Okay, so when can you have yours ready to dole out to everybody?
We can have ours ready by Tuesday, if we can exchange them by Tuesday.
Okay. Is it, I assume everybody's been kind of tracking this. Could everybody have what you think is the state of the evidence by Tuesday?
I don't think that's going to be hard to do if it's okay.
I mean, frankly, whatever the court reporter has is what's accurate. So it might be that I can just get that list from the court reporter and give it out to all of y'all. And if there is that might be a better way to do it. And then if there is a discrepancy and anybody believes that's inaccurate, we can take it up. So why don't I talk to and we're going to be, from now on, well, y'all all know Ms. Parker, but Ms. Parker is retiring in 1 week. I will have a new court reporter, and I know, it's the end of an era, but I'll have a new court reporter, Ms. Winfrey, who probably a lot of y'all know anyway, and she'll be moving forward. I'm going to ask Judge Glanville's court reporter to start working on transcripts, because I'm going to need them, but we'll all need them at some point probably, because just transcribing what's happened so far is going to take months and months. So we're going to shift not only judges, but also court reporters. So I will get with Judge Glanville's court reporter and ask her to give me a list of what has been tendered and either excluded or admitted or is still hanging out there. Give that to all of y'all, probably just through email from Ms. Rosser. And then if there is any discrepancies, y'all can let me know that, okay?
That would be great. Does the court, and I understand that there's really no way to tell accurately, but does the court have any idea of when we could anticipate receiving something
I
like
think
that?
pretty quickly. I mean, I've had a couple of communications with her already, and she seems pretty on the ball, and she's tracking it all on an Excel spreadsheet or something. So I don't think it'll take long. I think I can get y'all that by next week sometime.
Thank you.
Okay. Let me write my to-do list. Okay. All right, what else?
Your Honor, I'm reviewing all of the notes from representations made by counsels for each of the defendants, and based on my review of those notes, I don't believe that there are other matters that we need to address at this time that are properly addressed without the defendants here.
Why did you say it like that?
All right. And do you have an idea of when you can get me the list of the rulings so far?
Yes, Your Honor.
And I know that's a bear of a task, so
that's okay.
Don't want to be unreasonable about it.
Just 1 second, because we have already begun that process.
Great.
And let me, if the court will permit me to confer with our team members who are working on that.
Thank you.
Thank you.
I just dropped you a question in the chat, everybody. Do you think Judge Whitaker knows nothing about this case? Because she does seem to come across like she doesn't know anything that's happening. Do you think that's true?
Actually in on this case, or are you just standing in for Mr. Williams today?
I'm actually in on the case. I did file an inquiry.
Okay, thanks.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great.
She said Tuesday.
Thank you.
Y'all just dragging y'all feet. She said Tuesday.
All right. With regard to the most immediate scheduling, the kind of getting through, hearing argument on, getting rulings on the things we all just talked about that are pending. Is everybody available all of, and I guess I've already got y'all, unless Judge Glanville had excused you, I think I've got y'all, but is everybody available? And I'm not saying we're gonna be here 8 to 5 every day the week of the 29th, but is the week of the 29th, everybody's available to the extent we need all of those days?
The state is available.
Okay. Anybody not? Okay, perfect. Because I'm thinking that at least most of that week, that's what we're going to be doing, which means I am not going to be going to the judges' summer conference, but that's okay. That's okay. Okay. All right. With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. And I'll have to obviously make sure that all the jurors can do that. I don't know what their, pickup kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here and have them. So that's kind of going to be my plan going forward. And it may be that we want to go all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay? So I don't want to be waiting around till 9:30 to get started. 8:45. All right, so that's that. So a couple of things have been brought to my attention that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think. She's not even here today. Yes, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out, apparently, the closets. So now I've done that for the deputies. They'll be more happy. Okay, next topic. Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions and
comfort breaks.
We'll just leave it at that for now. There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening, and that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about? and why that's necessary. And if nobody wants to, then we'll just do away with it.
Yeah, I saw that. What were they doing? I've wondered what that was about.
I think it was originally to combat boredom.
All right, well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew, okay?
Sure.
Yes, sir.
Good morning again, Sergeant Master Mr. Huey. There are times where the defendant might need to listen to evidence, interviews, things of that nature. And I've made that available for my clients to listen to interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
Certainly understand that. Just maximizing the time that I have with my clients since I don't have availability with him outside of court every day. So he's here, we're here. So a lot of times I'll give him an opportunity to review evidence and things of that nature. So
all right.
That would be the only reason I want to ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right.
She ain't playing. She means business.
I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. Okay. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said everybody
is wild.
Not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered an order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now.
Oh my gosh.
Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption. But at the same time, you know, maybe some of this can be whittled down. And that is a wild paraphrase of that order, but I think y'all know what I'm talking about. What I want to know is, where are we really? I mean, I know, you know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say.
The appearance of impropriety. You want to avoid the appearance of a possible conflict of interest. We all know that this case is also being tried in the court of public opinion. Is there too much credibility damage that has been done so far? Would it save and resuscitate this case if someone else stepped in? In Georgia, if DA Fani Willis is disqualified, it's her entire office. It's the team that is gone. And then there's another council of prosecutors that would decide which office takes it over. The problem with that is that that new office could decide, you know what, some of these charges don't fit. Some of these charges aren't strong enough. We're going to have to reevaluate where this goes. And so that not only puts a delay in bringing these defendants to trial, including former President Donald Trump, but it also makes you wonder what's going to be left if Fani Willis gets disqualified.
The attorney right now know of a date that nobody from your team can be here. And I wouldn't expect that to be the case because y'all are in trial, but no, I mean, anybody getting married? Okay.
Are you all, let me make sure everyone can still see.
I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay? All right.
She don't want to do this. Or you can just...
All right, what else do y'all think that I need to be thinking about, or do we need to be talking about, or at least raising to talk about later? And anything from the state?
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Okay. All right. Mr. Weinstein?
No, Your Honor.
Okay. Mr. Sharp, anything?
There have been, this case, as you know, is enormous, and the discovery is enormous. There are certain, with Judge Glanville, we have some general rulings about some matters, but not particulars.
Okay.
I'm trying to give a heads up. This is an example, but I don't think this is the situation. I have filed a motion regarding, there was a wiretap in this case.
Okay.
And the judge overruled my objections and stated that the wiretap was legal. He made that finding. However, there are other issues about the wiretap and the particular things said in the wiretap. Some of those pieces of communication may be admissible, may not on an individual basis. Certain things like that, I'm just giving the court a heads up, have not been parsed through to the particulars.
Okay.
And we've discussed like the need to do those things, and some of those things we've kind of kick the can down the road a little bit. Mm-hmm. So they're still outstanding.
Okay.
I just wanted to bring it to you.
All right. So maybe when everybody is putting their lists of witnesses and what they're generally going to be talking about together, they could also, I don't know what happened to my mic all of a sudden. They could also include, if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies, if y'all can maybe list out for everybody what that is. Because yes, I absolutely want those things to have been determined before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
There's reports that we're still missing. The state has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing them.
All right.
That's been a recurring theme.
All right. If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist. That'll be something we can take up substantively, just so we start out all on the same page. That'll be something maybe y'all can do next week, and we'll take up the week after that as well. Okay, because if we need like 5 days of motions in limine, we need to do that. Okay.
Judge, I just wanted to make clear that the state has complied with its discovery obligations, and we have turned over all of the discovery that exists in this case. And as the court is aware, discovery is that which we have so we have turned that over, and we've actually gotten and requested. We've sought from outside our office any other materials that existed in the universe. We will do as the court has instructed and provide to the court a list of matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And Mr. Shard, I know you've been in my courtroom before, and typically I have, one side or the other list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. All right. And y'all, for any evidence that there hasn't been a ruling on yet that I'm going to need to consider the admissibility of, I obviously am going to need a copy of that. So if I've got 5 hours of some audio to listen to, I don't want to listen to that in court. I want to listen to that beforehand so that I know what we're talking about before we get to court to hash it out. So get me all of that as well. And that'll be more homework for me to do. Okay. All right. Then, so let's go through anything, either Mr. Williams or Ms. Sabashi for your client. Okay. Mr. Harvey, Mr. Steele.
No, not
okay.
Your Honor.
All right. Okay. The next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody while we are kind of in this pause to talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain any kind of plea at any time. It can be a joint recommendation. It will be non-negotiated since we're in the middle of a trial, but it can certainly be a joint recommendation, or it can be state wants this, defense wants that, or it can be we all want to keep going with this trial. I am here to give everybody a fair trial and everybody a fair shake, follow the law. But I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that. Okay? All right, so I think that y'all have a lot to do and I have a lot to do, and we will plan to get all of our filings and all of our responses in before the end of next week at the dates that I had provided. And why don't we plan to maybe not Monday, but Tuesday, the 30th. All convene here at 8:45 and just start tackling everything that got filed, okay? And we'll plan to go pretty much all day until we finish every day that week. And by the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week. All right, anything else from anybody?
I have a question, Your Honor.
Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress. For instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said, I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern, evidentially, constitutionally. I don't want it to be, you know, here's my chance to challenge everything under the sun. So I don't know if that answers your question, but it sounds like there are chunks of evidence that everybody has just basically not gotten to yet, and y'all have sort of said, all right, we'll get to that when we get to this witness. And if y'all have been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then if that's what the expectation has been, then I wouldn't expect y'all to have all filed all of your challenges. I don't know what's been going on.
Your Honor, that has not been the case. No, but because of the way that the court indicated that the court wanted parties to provide evidence regarding admissibility issues, I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is ripe and what is valid for contesting at a particular moment. I don't doubt those will continue to arise, but I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I.
Okay, so I don't intend to revisit rulings on evidence that's already come in. But for evidence that we know is out there and was going to be introduced a month from now with, witness Jones, if y'all have been doing that on a rolling basis and y'all know that there are going to be evidentiary issues with it, things that I would have considered motions in limine, then I want us to all go ahead and voice that now and sort it out so that we know when the witness shows up what can be talked about and what can't be. And I don't know if that gave you clarification. Okay. All right, Ms. Abbasi.
Yes, Your Honor, if I may, I have to disagree with Ms. Love that it's been going along that we've already had.
Leave bumpers alone.
Is not admissible. Just to propound on kind of what Your Honor was mentioning and what the task of the defense faces, we have a list of 8,000 jail calls. We haven't listened to 8,000 jail calls, and I think probably the majority of them are not relevant. Everyone would agree that they're not relevant. The state's not actually going to introduce all of those jail calls. However, defense, our burden, if we don't raise the objection, it's been weighed, and then it comes in at trial.
Okay, so that's why the witness lists with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram is going to be these ones.
Okay.
And Judge,
Yes, sir, Mr. Adams.
good afternoon. Again, Judge Keith Adams with Mr. Steele for Mr. Williams. Just to, I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just append to what Mr. Barnes was saying. For example, there have been jail calls, there are interviews, that generally speaking, there have been hearings on the admissibility of those statements.
Okay.
But the court has oftentimes said, I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that at that time. The court has routinely been doing that. So not necessarily kicking the can down the road, but addressing issues as they come up. And the court has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that, but there have been routinely times where we said we just disagree and we've had to take those items up. And I think what you would like, what Judge Landfill has asked, is that let's let you know about it as far in advance as we can. And that way you can set aside some time to deal with it without impinging on the juries.
Absolutely. I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can, and litigate everything that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it 1,000,000 years ago, their updated list that they're going to share with everybody should not include the Instagram post that they know they're not going to use. So, all right. So I will expect whatever filings y'all, I will anxiously anticipate all of them. Make sure whenever you file anything that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay? All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th. All right? Don't leave until you make sure Ms. Rosser has your cell information.
Can I ask a question?
Yes.
Judge Glanville had, for both sides, 2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that continues. That would be very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. The state knows, we're in the state's case right now. The state knows what it's doing. The state has investigative help. Make sure you have enough witnesses to carry us through each day and that they're ready to go. Again, that all just kind of falls under the auspices of let's be respectful of the jury's time. Mr. Harvey.
Can I assume, Judge, that we are going to continue with the opt-out rules so that you're not going to get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if there is something, y'all can bring it to my attention. Otherwise, we'll just keep rocking as before. All right, thanks everybody.
To be honest, remember the press, there was a rule in place for the members of the press to get the witness list on a Friday, so if someone will be excluded to be shown on camera, I want to make sure that's still in place as well.
Okay, so I guess y'all would have agreed beforehand that a particular witness shouldn't be shown on camera, and then who gave the list?
The state has been providing to members of the press the list of those persons, and the judge has made rulings regarding those.
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown, whatever kind of concerns, then they won't be shown in the, but
it wasn't exhaustive.
It seemed that that was kind of a witness by witness thing, and that there was an opportunity for input.
Yeah, there's an order that the judge entered, and there were certain reasons that the state could request that witnesses not be televised. I believe that was to be provided to us the Friday before, and then we would have the opportunity to object to that by Monday.
Right.
And then the judge would make a decision based on his criteria whether that witness should be shown on television or not.
Right.
And I believe that Mr. Harvey has a standing objection to all witnesses at this point.
Okay. Wait. To all witnesses being shown or being excluded? Okay. Well.
No witnesses excluded. I don't want to speak for Mr. Harvey.
All right.
And I'm in concurrence with Mr. Harvey.
Okay. Well, that's why I guess it's being taken up on a case witness by witness basis. So, Ms. Love, then you're providing that to the court and the opposing counsel. If there's objection, we're litigating it. And then are we saying it's like the next Friday that we then tell the press, or help me out on that?
Ms. Hilton says she has been providing that list. I will let her explain to the court.
Okay, because I guess I'm wondering, how is there a list if there hasn't been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially prepares the list.
All right.
Good morning, Your Honor. Or
good afternoon at this point.
What has happened is the week before, certain witnesses were going to come up the following week.
Okay.
We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as to opposing counsel. They would then decide, object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state is kind of the preliminary. We think this might be the case list. But Ms. Hilton, do you then give them and here's what our determination was list, or?
So normally the court has put on the record that Monday, whether or not that witness should not be shown.
Okay, so you've got your list and you either strike that person off because I said they can be seen, or you just go with what's on there. Okay, that makes sense. So yes, we'll continue with that as well. All right, we're in recess.
All right, so y'all met my niece. You met Judge Whitaker. What did y'all think about it? Tell me what y'all thought. Let's chop it up in the chat. What did y'all think about it? I actually have a guest coming by in a moment. And let's see if he's able to come on in. You can try again, Black Law student. I apologize that had that technical difficulty. You should have the link still. But okay, so what did y'all think about her so far? Let me know what y'all thought about her. Rate the good Judge Whitaker. I like it. Yes, she does seem organized, extremely organized. She's a time cruncher. I got you. She does seem like it. She does, for sure. Fair and strict. I got you. I'm just wondering how some of the shenanigans that have happened in the trial so far, how would those play out with her now? Because, I mean, it's fair to say 88 Love has gotten very comfortable with some of those things. So I'm wondering how she'll respond. Give her a 10. Michelle says she get a 10. I like her. I like her for sure. I like her. Order on the court. 9.8. Okay. I'm with you. I can totally agree with that. Totally can see that. So, okay, I'm waiting to see if Black black law student will be able to jump back in. But so far so good. I think this is going to be a pleasant change because she said, look, we're going from 8:30 to 6 every day. They're going to plow through this very quickly. Because a lot of the slowdown was the stop and go with the comfort breaks and the long and I think they were also not having court in the YSL case with Glanville. There was like a day they weren't even meeting. So that was pretty messed up. So this could be good. This could be good. Let's see what they say. What are they saying? Who's Donna? Donna said, no, just outside Marietta. Oh, okay, y'all have a conversation. Got you. Yeah, that's my sister from another mister. That's another Whitaker. She seems to have a good spirit. Okay. I'm just wondering, okay, it may be, okay, you are in an office building, okay? Let's say there's 10 executives that are working in this office building, okay? You and 9 other executives, right? And one executive is having a very bad time with the client. I mean, they're having a horrible time with the client. They're shouting matches. The cameras are there. It's being televised on the internet, so on and so forth. What's the likelihood that you're going to at least know what's going on with your coworker, your colleague in the same office building as you with this terrible situation I have with this client and they can't get it resolved? What's the likelihood that you're going to at least know something about it? To me, it just seemed like she got to know something. You had to have known that Glanville, your coworker, your fellow judge, the chief judge, is having a hard time with this case. Now, again, you don't have to go into a deep dive, but it's in your building. That's the thing. It's not like it's over on the other side of the country or even on the other side of town. It's literally in your building. Her office is probably close to Glanville's because she's mentioned that it's upstairs. So it's probably somewhere close to Glanville's, or definitely she knows about where Glanville's office is. So that's the part I'm like, I don't know about that. Now, granted, again, she don't have to get into the deep weeds. Maybe she has a lot of other things to deal with. So she didn't go into the deep weeds of what you mean or anything of that nature. But you knew what's going. You had a little bit of. You knew something. You knew something about this. Let me see. Sorry about that. Looks like my guest is having a little bit of technical difficulties. Hold on one second. All right. Sorry about that. Okay, I'm just texting to tell him about how to get back on. All right. Steele and what does Retire say? Steele and a few others threw a fundraiser for her, so she probably knows Steele, but wants to be honest on the case, at least till she proves otherwise. She does seem to be fair so far. Okay, got you. There's some large outrage. Oh, is that what you're saying? Is that what it is? There's a Microsoft outage? Oh, that might be part of it. Okay. So I like her so far. I do. I think she seems okay. And I know she want to move this case along. That's what I know. She said, y'all not going to be up in here wasting my time saying this crazy stuff. Y'all going to get this thing done. Y'all going to share this evidence or whatever. Y'all going to get this thing moving. So I think it's going to be good. I still don't know how the likelihood of it lasting all the way to the end, but who knows? I mean, maybe because she kept saying, she making it sound like she planned on being there. So I don't know what that means in regards to like the mistrials and so forth. So can you tell? Okay, here we go. Black law student in the building. All right, you are muted, my friend. But you are on. You can come on. Unmute yourself. It says you have muted yourself, my brother. All right. Well, I got a guest on. We're waiting for him to get. It looks like it might have a few technical issues. Let me see if I drop it back into the green room. All right, put it back in the green room. But let's keep going here. There's a huge Microsoft outage about 4 o'clock this morning. Okay, that might be it, maybe. Wow. Microsoft update that's caused a few airports.
You hear me?
That's not a small problem at all. Wow. Airports and cities are shut down worldwide.
Can you hear me?
Good gracious. I can hear you. Yes, Black law student, I can hear you.
Yeah,
Are you
it
there?
seems like Microsoft's having an issue. It's saying
Yeah,
Microsoft,
I'm literally reading about
I'm
it right
here.
now.
Microsoft is it's failing the JavaScript on my computer.
Well, here, let me pull you in at least so we can hear, at least test to make sure everybody can hear you. That'll be a good opportunity to see. Let me bring law student in. All right. Now, no jokes because this is Black law student, and because of this, the havoc with Microsoft, it's a black screen. So it's serendipitous that it would be a black screen for Black law student. How's it going, man? How are you?
How are you, sir? I'm sorry. I'm trying to. It's saying Java Microsoft failure. I don't know why it's doing that.
No problem. You know what? We're gonna let it slide. We're gonna let it slide today because you're gonna be our resident smart person. So we have to take what we get and not pitch a fit. Are you still there?
Right, sorry.
Okay, there we go.
Up for you. Yeah, I'm still here.
I appreciate it. So what'd you think about Judge Whitaker? What'd you think about her? Whoa, they're saying ATMs is acting up? Okay. This is wild. All right, I think I lost my guest again. So, sadly, Black law student is having some technical difficulties, and apparently this is something that a lot of people are experiencing today. Man, that's craziness. But let's keep going. So thank y'all so much. I don't know. How do you instruct the jury after this?
Sadly.
And in my opinion, I think that's going to be another hurdle that they're going to have to overcome is the fact that the jury, unlike Judge Whitaker, the jury knows about this, okay? Because I'm pretty certain that Kristen is a juror. She's juror number 7. I know it. So don't tell anybody, but I mean, for real. So they're already aware of this, man. They already know what's going on. It's not like the first time they've heard of it. So I think it's going to be a mess. Just an utter, complete mess. Oh, Janelle said, whatever she knows, I believe the shenanigans will stop now. I agree. I think she seems to run a tight ship. I hate that her court reporter is about to retire because that's going to throw off a little bit as well. But no, she seems like she runs a tight ship, and it seems like the shenanigans will not happen. My conspiracy theory antennas are going off. Really? What is your conspiracy? Let me put my tinfoil hat on real quick. What is your conspiracy, Q? Don't hold it back. Share the tinfoil. We're all here for it. Yeah, see, everybody wants to hear that. I want to hear what your theory is. Q here. Matter of fact, let me do this. So, in honor of Black law students, so I can make sure this all works, I'm going to drop the link in the chat. I know you ain't doing no work, Q, so just don't even fake the funk. Just come on, jump on in. I just dropped the link for you. I do ask that you have your camera on. I do ask that you keep the profanity non-existent and that we have a good conversation. We're going to be talking about this specific topic, so we'll stay on that topic, not anything else. Like, yeah, Jason, I want to talk to you about whatever, your Blue Yeti cup. Well, that's not the time to talk about that. Now is not the time to talk about No, she is familiar with the new court reporter. Please don't. Okay. That's fair. That's fair. Now, I did hear something that was a little bit strange to me. She said, I'll go get the transcripts from the previous. How long is it going to take to get those transcripts? Because it's been better than 7 months. I mean, they've been in trial for 7 months. That's crazy. Let me see what. Q, are you jumping on? Q said it's a work day. Okay. I got you. I don't think the MS outage is the incident. I think it's part of the bigger plan. Uh-oh. Q got a bigger plan. Uh-oh. I'm going to leave that alone then. So I think Judge Whitaker at the current moment, she seems like a straight shooter. She seems like she knows what she's doing. I think she runs a tight ship. I just don't think this thing has been so out of pocket for so long. I don't know how she's going to pull it back in. But we'll look at this. Look at this. Ladies and gentlemen, boys and girls. But you're muted. You're muted. You're muted.
I think she runs a tight ship.
Oh, and now we got you. Ladies and gentlemen, boys and girls, Black law student, how's it going?
How are you, sir?
Quite well, thank you.
Sorry,
I hear that.
Some technical difficulties.
No problem, man. I hear that great content that you're listening to back there. Tell that guy to be quiet back there, though.
There you go. I got it.
I got you. All right. Well, real quick, tell us who you are, and then I got a lot of questions for you.
Got you. Name's Corey. I'm a 3L at George Washington Law School here in DC. That's pretty much the bulk of what I am as a Black law student.
All right, so he said he's 3L, so I don't know if that's like some gang terminology or whatever like that.
Third year. So in law school, it's 3 years. When you're 3L, kind of what Brian Steele was saying, he had a 3L student with him. You're pretty much like a lawyer.
Right. I love it, man. Well, Corey, thank you so much for coming on. Everybody's saying, what's up to Corey? This is Black law student. So go ahead and put Corey in the chat and say, what's up to Corey? All right. Now, we have been, contrary to popular belief, I was not shopping on Temu during this. I was actually interacting with Corey. He's been sending me some text messages, sending me some great insights because he does know what he's talking about. So, okay, here's my question. And because Corey broke this down to me, I was like, well, why is she not ruling on the mistrial? I kept typing in, mistrial. And Corey broke it down. So you want to explain why Judge Whitaker did not move on the mistrial right now?
Well, I think, too, she has to be very careful infringing on the defendant's rights. And Brian Steele made it very clear his client has the right to be there at any court proceeding. So she's treading lightly with that and saying, I'm not ruling on anything without your defendants being here.
That's what it was. So, and I was thinking, like, yeah, that was kind of foul. I mean, to think like Brian Steele would get the whole case thrown out and Young Thug and then would not be there in there. So it would probably have to wait until everybody's there.
It also sounds like they may not bring up a mistrial. It seems like they might get a fair shake at this.
Okay. So now, okay, I can accept it. Either way, it's going to be must-see TV. Whether she kicks it out next week or it goes all the way to the end, because I don't think it's going to last nearly as long as it was. They should have had her on this from the day one, because it sounded like they would be much further along. But go ahead.
If you look at ADA Loves, her temperament, her body language, she wasn't really feeling today at all.
She's dejected. She likes hearing Jack back there, the service dog. She's gonna get an hour and a half a comfort break. She's gonna get a 2-hour lunch. Now this lady said what, 8:30 to 6? That made me start itching. Like, whoa, what is that? What kind of hours are those?
Well, to me, it's very crucial. She had to get control of this case very quickly.
I agree. So when she comes on, how will a judge get up to speed? Because it just seems like there's been so much going on. What do you have an idea like what the up to speed process is for them?
In 2024, she could pretty much binge watch YouTube for the weekend and kind of get up to date with this trial.
I'm dead. Hey, Judge Whitaker. Jason Whitaker, hook your boy up. I need some views. That would be hilarious. I guess you're right. I guess you're right.
But those transcripts will probably be key for her to get up to date in a strategic and fascinating way.
Right, and not a biased way. Because come on, I mean,
Yeah.
if she was binge watching YouTube, she'd come back in there and throw 88 Love in jail or something. Like, y'all are crazy.
For sure.
Okay,
But
so
as you can
go ahead.
see, though, in a lot of these motions, Brian Steele puts YouTube in his motions
Oh, for
in
sure.
the timestamps. So she could watch Law and Crime and kind of get up to date in some type of way.
Double speed.
Yeah,
She'll catch up. She could also reach out to Q. Q is our resident binge watcher, so Q can give her like the cliff notes of what's going on in the trial.
But I also noticed that she set the tone for the defense too, with the defendants. Listen, Young Thug, we don't need all them clothes back there. You know, we're not. Listen,
He
this
probably
ain't a
does have
fashion
a whole
thing.
wardrobe.
It's
I've seen him
probably
in a
his
lot of
wardrobe
different
he's
clothes.
talking to.
Okay, so
You know,
where do they keep the clothes? Where do they keep them? I didn't
it's a
even think about
closet.
that.
It's a closet. So they come down in jumpsuits, and then they
Yeah,
have a right to go into the closet, change their clothes.
got it.
You know,
Gotcha. Okay.
if he was to just wear like a suit, it probably wouldn't be like an issue. But he's younger, so
Oh no, he be fat. He be flexing. I've never
yeah,
seen him in the same thing. No, I
yeah.
take that back.
That's
I've seen him in the same thing once, a couple times. Yeah, sorry about that, but he
well.
definitely has a large repertoire in
Some
there.
of some of the problem is the court's responsible for those clothes because he can't take it back with him.
Got it. Got it. Okay.
So they assume financial responsibility too.
Oh, okay. So that would have been on Glanville to put the kibosh on that, and he clearly, I guess, maybe wasn't. Is that right, or what do you think?
Well, I can see like court etiquette wise, I think Glanville let a lot of things go that wouldn't be in a normal court setting.
For sure. Yeah. And
Eating and all these other things.
I've never seen anybody eating, but like
Food, headphones. Yeah, I seen young fella eating a whole bunch of stuff. You know,
really,
headphones, all these other things. Yeah,
I saw the
he's not gonna
headphones.
let that fly. Yeah. And
Okay,
it
I
seemed
saw
like
the
there'll be
headphones, but
not
I
too
was
many
thinking that
comfort
was.
breaks.
Say it again.
There's not gonna be too many comfort breaks either.
Oh no. I was already discomforted. I'm like, Lord, where Jack at? I need Jack. So yeah, that's gonna be a mess. But I think they're gonna if they kick it back up, they're gonna get a lot done. So yeah, okay. Let me see if anybody any questions for you. She should sure read the charts and the chats and the comments. Oh my gosh. Cut the wardrobe, no snacking. Absolutely. I'm sorry, I did not see thug snacking, but okay. Y'all clearly saw that. I just wasn't paying attention. Okay, no comments or no questions to you specifically. So let me ask you this. Looking into the future, when do you think that we'll be back up officially based upon what you saw here?
I think Monday. I think she's going to be tight the following Monday. She wants everyone back there at 8:45.
29th, yeah.
Yeah. I think she's going to allow everyone to put their motions. I believe you're going to see motions for bond before you hear motions for mistrial.
I forgot about that motion. Yeah, we need a motion for bond. Okay, what do you think about? You read her motion. I mean, their motion for bond. What do you think?
Listen, if Donald Trump got a motion on a RICO, young Thug can have similar arguments on the same charges, if you ask me.
Okay.
The reason not to get bond is if you have a risk of fleeing the country. Well, just like the president, everybody knows who Young Thug is. So I
For
don't
sure.
think he's going to flee the country. He's a recognized face.
For sure. Okay, I like it. All right, so here's from retired. Corey, if she goes back and removes Woody, does she kill the case?
It's a possibility. Brian Steele on carry motion, meaning not filed yet, brought up this issue that he's going to file a motion for this afternoon. That he wants the case to be. He wants the case to be rewind.
Okay.
And there's case law that says that if you are recused from the day you ask for it the case has to be rewind.
Right. And I thought that's where they were going to take it. So that's
Yeah.
so back to what would have been like June 10th.
Yep.
Or yeah, basically up to the day Woody. Say again.
Videos
Oh, thank you, God. Hallelujah. Yes. Get rid of the videos. Hey, as much I love Woody, love him like a biscuit. If this thing moves along and you don't have to have Woody in there, I mean, it'll be sad though, because he was definitely comedy. But no, I got you. So you're saying that he's going to institute the rewind principle?
For sure, I think you.
Okay. Yeah, that's what I read. I don't know. I read it somewhere that they were going to rewind it if they got a new juror. I mean, a new judge. Yeah, this is interesting. Home Office says, how can you get a lot done when Woody was disenfranchised from the beginning? And if I'm understanding correctly, and please chime back in if I'm not understanding you correctly, Home Office, Woody came in not wanting to testify. So I think basically, if I'm understanding correctly, like nothing that he said was really what he wanted to do. So wouldn't that be a level of, wouldn't that be problematic from the word go?
Yeah, I don't know if the too far with this thing and rehash issues.
Mm-hmm.
So here's the funny part to me. Woody is the reason this case exists. And he's also the reason why it's falling apart.
That is a very keen observation. And I think the state has too much weight on Woody. Yeah. And I think that's problematic for them.
My camera's going on and off, but
okay, I can definitely see you are freezing every now and then. But I'll get this last question so you don't have to keep. I got 2 more questions for you. Sorry about that.
Yeah, something with this sauce that's messing thing up.
Okay. So let me just drop this if this is okay.
Sure.
How can the jury even begin to judge this after seeing the first half shenanigans? And I think Home Office is being very, very optimistic by calling it half. I don't think they're about a quarter of the way through, truth be told. But how can the jury even make a decision with all of this stuff coming around? I mean, the shenanigans in court and outside of court. You got any perspective on that?
Yeah.
You breaking up again, my friend. Bill Gates is hating on us, man. I'm gonna insert an Apple joke in a second. You know he's on an Apple. You know he's on an iPhone. All right, here we go. Try again. Got him back in. All right, got it. Are you on an iPhone?
I am on an iPhone.
See, I'm just saying, man. All right. How can the jury parse through all of this, sift through all of this shenanigans? How are they supposed to be able to do that?
Well, here's something interesting. If you remember, Brian Steele talked about his motion in this hearing this morning.
Mm-hmm.
He asked the judge in his motion, he's going to ask the judge to confiscate their notes. He said that. He said,
yeah, he did say, yeah.
You have to confiscate their notes if they wrote notes.
Wow. So they really are writing notes. I hear that, but I'm like, I didn't understand. Like, wait, so they give you a notepad every day and they take it back every night?
Nice thick notepad.
Get out of here! I didn't realize that.
Fix it at the end of the night.
I did not realize that's really what he meant. I didn't get that. Oh my gosh, that would be miserable, man. All right. Last thing, or the last question I can currently see. Will they have enough evidence to convict without Woody and those videos?
No.
I don't think so either.
No,
I also want
to. Case is over. Remember, A.J. Love made it very clear they needed Woody to testify because the rest of the witnesses build upon his testimony.
Yep, she sure did. Yeah, so it means that if Woody doesn't
testimony, The case is over.
Yeah, if Woody doesn't lay the foundation, nobody can build a second floor for sure. No, that's a great point. And Ron,
that's why they wanted the ex parte. They wanted the ex parte for that reason.
Good point. Good catch. So Ron says here, it appears that the state has lost home field advantage. Should be interesting. The box has shrunk. I agree. Because I think when you had Love and Hilton and Glanville working in concert, what did Brian Steele call them? A prosecution? He called them teammates. But then what did he call them today in the motion? The secret. Brian Steele is just petty. He was so petty.
Yeah,
in a good way. In a good way. Let me real quick. I respect Brian Steele. I just think what he's doing is extremely strategic. And I use words like petty and comical. I think I called him a savage one time. Those are all out of respect. Trust me, I think Brian Steele is an excellent lawyer. Everybody who talks about him says raving things about him, and I don't think he's paying them. So that's the only reason. I'm just saying, like, the things he says are comical and petty, but I'm not trying to disparage.
And his
Brian
wife
Steele.
is a very good lawyer too, by the way.
Yes,
His wife
yes.
is a very good lawyer. And a
Absolutely.
lot of his writing, I would not be surprised if his wife didn't write it. I read a lot of her writing. She's a very peer-reviewed lawyer.
Well, look, hey, they're a team. God is brought together, let no man break asunder. So Brian Steele wrote it. If his wife is one that penned it, Brian Steele wrote it. He gets credit.
Yeah. He's a very good lawyer.
Oh, here's another question from Transplanted Texan. Says, didn't Judge Whitaker say that the state witness list should be reduced? What kind of blow is that to the state?
Well, this is what she did, and I'm so happy she did this. She's saying, listen, I need to know who you're calling and what they're going to talk about. Because it's not going to be cumulative. No more cumulative. I'm not sitting here for that. She said, I need to know who you're calling and what they're talking about, and I'll rule on that list.
There we go. Yeah, I think that's going to be key. I would love to. I can't wait. I cannot wait to see. Because, again, I was told it was almost 300 people on the list in total. But I mean, let me say, I've heard two things. It was 150, and then I heard 300. I just know that they're not anywhere halfway done with either of those numbers.
Well, the initial filing was 456 witnesses.
See? That's crazy. So I like it.
Which is not unheard of. Prosecutors do that to scare. They don't normally call 400 witnesses, but it seems like she might be trying to call 400 witnesses.
Because they don't have any other case, though. Yeah. And like we've mentioned already, if you're building all of this off of Woody, I mean, the dude is on Instagram. The dude is out here on Twitter wilding out. He done started a YouTube channel just talking. I'm sorry. I don't know if he's going to be a good look for them. Because, again, I mean, he's becoming a meme. So if that's all you have, you might need to look at some, as Judge Whitaker said today, maybe you should look at some plea deals. And
I think Brian Steele is going to destroy Woody on cross-examination.
Oh, unequivocal. So do you think they're going to call Woody in? So let me ask you, once they decide they've clarified everything, fixed what the attorneys are wrangling about, and the jury is back in the box. And let's just pretend that they polled the jury and none of the jury knows anything. They're just as green as they were when Glanville sent them home a month ago. And Woody's in the witness stand. So you think Brian Steele is going to eviscerate him, or is it going to be really?
It's going to be a field day. Well, there's two issues with witness lists that you're going to see come up in the next couple of weeks. One of the main things is that Brian Steele filed a motion you talked about this morning. He's going to be adding ADA Love and Hilton to that witness list. Now, if you go back to the Alec Baldwin case, right?
Yeah.
That just happened. Think about, they had to call that prosecutor to testify.
That was craziness.
The judge had to, remove her from the case to allow her to testify.
That's crazy.
So I would not be surprised if 88 Love or 88 Hilton get excluded from this. I don't think the judge will exclude both of them, but I believe the judge will exclude one of them.
So if they get excluded, are they no longer on the case?
Yeah.
So, okay, me and you are counsel and co-counsel, and we're suing Kiana for being ridiculous. For whatever reason, I have to be removed because I got to testify. After I get done testifying, I can just go home?
Yeah, you're done. Well, they're going to disqualify you from the case.
Wow.
You can't testify. You can't be a witness and the lawyer.
You're right. You're right. All right. So I bet you Hilton is probably sending notes to Whitaker. Go ahead.
Remember about day 20, well, before the trial started, 88 Love filed a motion to remove Brian Steele from this case for the same reason.
Sure
She
did.
expected to call him. The reason why the judge denied that motion is because what she was going to have him testify for didn't make sense. It really wasn't a thing to have him testify to. And I think the subject matter was that some of the theory is that Jeffrey was shopping Brian Steele around to these defendants to be his lawyer, like he's the mob boss sending his lawyer to get you out of jail.
I remember that, and I remember reading, like, that's like me telling you, hey, this is the guy that detailed my car. Man, he does a great job. Go check him out. Like, I didn't feel like it seemed like a referral more than like he was going to get you. Yeah, I'm like, I thought it was kind of reaching. I'm like, come on now. 88 Love with her green nails today. Go ahead.
It would be different if Brian Steele got a retainer from this guy. Brian Steele got some money from this guy.
Right.
But he just took a phone call, and actually he told the guy, turn yourself in.
So it sounds like he's doing the right thing, but okay, this is interesting. I didn't know this. Bumpus and Woody both deleted videos off of YouTube and Instagram claiming a hack. Okay. I've said it. I thought they shouldn't have been on there like that, in my opinion. Yeah,
me too. Not a good look for her. And Woody could get in trouble for that, actually.
Say again?
Woody could get in trouble for that.
I was wondering. It was moving very, yeah. I mean, I've talked to people. I'm like, yeah, I probably wouldn't do that. I would. Now, I do think he has some. I do think he caught lightning in a bottle, and he should try to maybe capitalize on that. Maybe start a T-shirt line or something funny like that. But some of the other stuff, and get around some smart people that you trust that are going to take care of you and help you move. Because apparently his education wasn't where it needed to be, which I can understand. There's no shade thrown there. But being on everybody's YouTube, being on everybody's live, I didn't think that was going to work out well. So hopefully,
I can say this: what was a little shady to me is if I fire you, I'm not about to go on YouTube and play around with you. If I fire you, oh, she's fired. Now I'm on YouTube taking trips with her to Miami. I don't know. Do all that.
What?
Was she really fired? I don't know.
Wait, what? Wait, they went to Miami?
Yeah, they were in Miami on YouTube on Instagram this weekend together. This is weird.
Man, hold on. Okay, we might need to turn it. We might need to get offline and talk about this, man. Wait, hold on. Okay, well, yeah, I'm gonna stop.
We'll leave that alone. It's a little shady. If you fire me, we're not going to take trips together.
Yeah, that was looking okay. I'm gonna leave that alone. So Q said, and I think this is interesting. I don't think the state has proven anything. In my opinion, my pre-K law student, I'm not a 3L. I'm no L. Okay. She says, why would the defense look at plea deals when the state has done nothing to prove its case? I don't think they've proven anything either, but go ahead.
Let me tell you why the judge did that. That's a hint to the prosecution. You might want to get a plea deal. This ain't going your way right now.
I picked that up. I got you.
Judges often hint that. Y'all don't want to plead this out. It's one of them type things. You don't
I
wanna,
got you.
you don't want to
So
put
there,
yourself.
no, I agree. I can totally see it, but I can also see Brian Steele and team over there. Like, absolutely not. You've proven nothing. You've barely even proven that the man is dead. Like, no, you're going to have to work for this. I think that's what Brian Steele, how he comes across to me. Like, you're going to work for this. If you get a W, you're going to earn this W. And that's what I'm getting from him. So I agree with you. That's probably what Judge Whitaker was doing. But Brian Steele's like, anything short of an apology and you buying the first 10 rows of his next concert, no, I'm not going to take it. So
That is unheard of. During the middle trial, judges like, well, you want to take a plea deal? You want to talk about pleas? That's what happened before you go there, not in the middle of it.
well, okay, let's be honest, Corey. Even I, a pre-K law student, knows this. Nothing is normal about this case.
Yeah, no.
Nothing is normal, man. From the word go, I think it's fair to say this case has been really, really bonkers. So I'm not terribly surprised. But I am going to ask you this though: just what you saw with Judge Whitaker, knowing that she seemed like she's pretty straightforward. How long would this case have taken if you think Judge Whitaker had been on it from the word go? They're currently on, this is day 101, and they've been in trial for, 7 months? How long you think it would have lasted?
Probably 7 months. We would have been in closing arguments right now.
Oh, okay. Yeah, I can dig that. Really?
Yeah. This is a multi-defendant case. It's not like a week thing. It's going to take a couple weeks because you got to build the case up when you do multiple defendants.
I got you. So I've been asking.
Would have been a 5-month trial.
Say again?
Probably would have been a 5-month trial.
Okay. So I've been asking really smart legal people this. Do you think this is another example or shining example that states do not have the business of filing RICO against people, but rather it should be the feds?
Yeah. I think about the Federal RICO Act, right?
Yeah.
One of the
sure.
things that require the Federal RICO Act is it has to be something with interstate commerce, has to be money involved, right?
Yeah.
There's no money involved in this. When you look at real RICO charges, the kingpin that they're alluding Jeffrey Williams to be, there's always a financier being audited to look at him funneling money back to the organization. They don't have no financial activity that this man gave anybody money, made anybody do anything. How do you run a gang and there's no money being traced?
It was in crypto.
I guess so.
It was NFT. See, like his album cover was an NFT, and they were like, "Okay, I'm trying." I don't know. That's a great question.
There's no money to be traced. The mafia is why they had the RICO Act in the first place, and you can trace millions and billions of dollars back to the mafia.
Well, Corey, if you do that, then Corey, I'm going to go and challenge then that the election interference case would be very problematic. But I'll go. Okay, I'm gonna reach back in the crates and say then, following what you just said, there was no money exchange in the Atlanta cheating scandal.
True.
Now, well, hold on. Let me correct myself. If you're familiar with this case, back in the early 2000s, Atlanta Public had a merit system where if your children showed and demonstrated growth and their standardized test scores, you would potentially be compensated for it. And if I'm not mistaken, because I wasn't in APS at that time, I want to say the maximum is $2,000.
Okay, so there's some money there.
There was some money there, but hold on. It wasn't like a pound for pound. Say again?
There's some money in the Trump case. Political donations. They can make. That's why the feds can make that argument, right? Political donations coming into Georgia. You can make that case with the gang.
So I think then the feds could probably make up those. Again, let the feds deal with the federal RICO charge against the election interference and against Young Thug and even the teacher scandal. Yeah. I guess maybe there is a little bit of money involved, but I don't think states need to do it.
let me tell you how easy Georgia makes it to file a RICO charge. Okay?
Oh my gosh, go ahead.
If you go to Tom, you go to Tom to get his taxes done, to
Yes.
get your taxes done, right? Tom legitimately does your taxes. Okay? You
Okay.
tell me, go to Tom to get my taxes done. I go to Tom scams me.
Okay.
I send somebody else to Tom, he scams them. Even though you introduced me to Tom because he legitimately did your taxes, now we all could get a RICO charge in Georgia. Because Tom scammed everyone and you introduced Tom to other people to scam. That's how they're going to view it as.
But you're victims though, right?
That's how easy it is in Georgia because we even though you went to Tom legitimately and Tom legitimately did your taxes and did not scam you, because you shared him with other people that he scammed, now it's a racketeering case.
Man, get out of here.
Yeah. That's how easy it is in Georgia.
Wow. Man. I need Jesus to come back, man. All right. I think that's interesting. So you think, well, so in your estimation, Corey, you believe that this case will in fact the jury will come back.
For sure.
Are they going to poll the jury? They got to poll the jury.
The prosecution should, if they have an ounce of common sense, to poll them.
And okay, let's say this. They poll the jury and they find out that, Kristen, juror number 7, she been rocking out the Young Thug. And who in this is, she's juror number 9 and she be hanging out with Woody. She be riding an ATV with Woody down Metropolitan Parkway. So they find out that several other jurors have been compromised. And now they no longer have their alternates and whatnot like that. Is that a mistrial then?
For sure, 100%.
Wow. What's the likelihood that you think the jury is going to be able to make that, hit that standard, that they know nothing about this?
I really got to think about that. I would hope juries do what they're supposed to do and not discuss this case, read about the case. But I don't know, that's a hard twist. What I would say will more than likely to happen, they will come back, she will grant bond. I think that's a fair argument.
I do agree with that.
She will grant bond.
Yeah.
But here's the thing. Do the defense really want a mistrial?
Only if prejudice.
So. I think they're winning the case.
Oh, I think they're winning for sure. I'm just thinking, if I can get, this is my thought process, and please feel free, because I don't know anything. If we can stop this trial today with a mistrial and not have to go back and redo it, I want to stop it today versus going all the way to the end of December, because I still got to pay y'all. Sure. All the way to December, and we still get a mistrial, or we go to, and we still get a not guilty, or whatever like that. Like, I think stopping it now would be better. That's my 2 cents. But what do you think?
Well, if you get a mistrial with prejudice, and that's what that
gotta get prejudice,
really
right?
They want prejudice with it, right?
Right.
There is some double jeopardy argument here, and I'm gonna tell you one of the biggest ones any lawyer should bring up, and one of them would be, according to federal guidelines, when you have a second trial, right? Suppose they get a mistrial, the state brings up these charges again. You are not supposed to talk about the first case in the second case.
Right.
It's a retrial. They can't do that. They have to bring up the first case for them to understand, how do we get to a second case?
Gotcha. Okay, got it.
And
okay.
That's how they're going to say the prosecution goaded us into doing this. So that's their fair argument. That's their double jeopardy argument there. Now, do you want a trial where they have to bring the charges up? I don't think that's fair for you to get a mistrial and then the charges get brought back up, because you're giving the prosecution 6 more months to make up some more evidence.
Gotcha.
So that's my little take. I don't know.
No, I got you. All right. So hopefully, how much time I got with you?
I got a couple more minutes.
Okay, real quick. Janelle says if the case doesn't involve money, then why would the state prosecute it as a real RICO issue?
Because the state doesn't have to have that burden like the federal government does. The federal government has to talk about money. The state, Georgia RICO is so open. It can just, be 8 people get on the bus together and you're on a RICO. It's very
Or in this
broad.
live chat. All of y'all on RICO.
We can all get a RICO right now.
We can all get RICO. All right, real quick. This is the last one I think I see right here. What will they do if a jury if a juror says they have been compromised? I think, let's just say there's 16 jurors, there's 12 jurors and 4 alternates, and only one, and that one is Kristen. She says that she was rocking out to Young Thug, hanging out with Little Woody. She got a "What do you mean" shirt and all that kind of stuff like that. So she's compromised. What happens?
Just go to an alternate.
Okay. So does she get sent home?
Yeah, she's out.
She gets home. Does she get paid?
It's only $25 a day, but yeah.
Man, give my $25. Man, give me my Starbucks and a sandwich. Man, it's okay. Is it not? I was told if the case goes so long, the amount changes. Is that true or not?
Well, I don't know. No, I don't think so. But
okay, I don't know. It was somebody crazy in my pre-K law class. I would hope so too, but it was only I think they said it was 25 and it goes up to 50 after a certain point. But I'm like, that's not really.
It works that way. The feds, if you're on a federal jury, it increases as you go further along in the case.
Gotcha. That might have been what they were thinking. Okay.
Worst case scenario, there is opportunity where the jury gets sequestered and they just have to stay there.
Wow.
And they got to get in hotel rooms and stay there for the rest of the trial. That would be bizarre, but there's a possibility.
Bro, that'd be insane. If they don't file the motion for mistrial, then how they can't act on the issue related later? I don't know if I got what you're saying. What, why, and whose. If you retype it for me, I'll gladly ask real quick. And then here's Transplant Texas just gives, these are the Fulton County jury FAQs if anybody else wants to dig into it. These are the standards for Georgia's jury and such of that nature. Well, Corey, man, thank you so much, man.
I appreciate you, man.
Man, it's a lot of fun. I would love to have you come on again or come on
when my computer works.
when your computer works. Might need a hard reset. But no, that was cool, man. I appreciate you, man. And so you feel like they are going to kick back up on Monday, not this Monday coming up, but Monday after, and you feel like they are going to go to get the jury and go all the way to a verdict. Is that what you're betting on?
It's a strong possibility. You're going to have to wait till next week to see what motions are filed. And
Got it.
She's going to have to take these things up. It seems like she's very eager to take these issues up. I will say that. She's very eager to take these issues up.
I can dig that. I can agree with you 100% there. I just think she seems like she's...
Play.
Say again?
She doesn't want to play. I can tell you that.
No, she wants to get done with this, and I think you're right with that. So, okay, I love it, man. Well, Corey, man, thank you so much, brother, for coming up, man. You know you are welcome whenever you want to come over here and holler at me. You let me know, and
I grow my beard a little bit, man.
Oh no, we got you tight, man. We're gonna get you taken care of, brother. Don't you worry about it. Did you get your discount code?
Yep, and I ordered it. So
I love it. I'm gonna go talk to those guys on Tuesday, so I will see if they already got your shipment ready or whatever. But that's cool, man. Appreciate you, brother. Hey, Corey, be good, man. Thank you, friend. That was Corey, the wonderful chat participator, Black Law student, and he's been texting me and sending me some insights. I know y'all been wondering, like, man, dear World Christian, you seem like you know what you're talking about. Well, I don't. I've been reading Corey's notes. So thank you so much, man. That was a lot of fun. I'm glad he stopped by and gave us a little bit of that insight. Drop Corey in the chat. Let's just go ahead and spam Corey in the chat. Let him know we appreciate him coming by, spending some time with us today, and all that kind of good jazz. And I thank you all as well. Looks like about 100 of y'all were watching with us at one point. I really appreciate it. I really appreciate y'all hanging out with me, listening to the trial, giving me your insight and your back and forth. That was fantastic. I do want to go with what Donna said right here. I agree with you 100%. If Judge Glanville was like Judge Whitaker is, I think we would be having a whole different conversation right now. An entirely different conversation. But I just don't think I don't know what the problem was. I don't know Glanville. I don't know Jack. I'm not going to speak bad about him. But it just seems and comes across to me that Judge Whitaker, she's like, look, I'm ready to get this done and keep it moving. To me, that's so much better. So I think that's really what we've seen is this. I think we're watching court management at play. Because, I mean, she's already bringing it in. She's already coming in and saying, look, we coming in here at 8:30. We're not going to be playing games. We're leaving here at 7 or 6, which that already gave me allergies. But, look, hey, and they're going to do it all 5 days. So I know Glanville did have some other responsibilities in the court. So I do want to give him a little bit of grace there because he is the superior court. What is it? He's a chief judge. There we go, the chief judge. So he already has some responsibilities. So I want to be a little gracious to him. I ain't going to say bad things about Glanville. But hopefully this case will get up and running and it will be chugging along. I still think it's a mistrial, but I can see that maybe defense sees that it could go well for them and maybe they'll just get bond and keep it moving. So I love it. All right. Thank you so much, Connie. Connie says, we love DWC. The best live chat ever. Well, thank you for being a part of the best live chat ever. Thank you. I appreciate you so much, home office. There's been a lot of faces in here that I've not noticed before, and I want to say thank you to everybody, whether you've come by from another channel, you saw me on another place, or whatever like that, or you just said, hey, let me check out this case and let me see what this dude is talking about. I really appreciate y'all. Thank you so much to each of you. Everybody that was with me earlier, discussing my children, they are actually on their way back. They're on their way back now. So they went to the mall and now they're on the way back from the mall. And I love those girls. They're something else. But anyway, everybody, I want to thank you so much. Let's do this again real soon. I will see you all probably tomorrow unless something pops off because, it's only 1:30, so a whole lot of stuff could happen. So let's do it. Wow, from Australia? Wow. Thank you so much for stopping by from Aussie, the land down under. I appreciate you. Thank you so much. And I do want to still kind of review the RNC. I know I said I was going to talk about that today, but then Brian Steele made that motion, so that took up a lot of the time on the top end. So I will go over the RNC. I have a guest that wants to talk about it. We just haven't nailed down if it'll be tomorrow or if it'll be Sunday. So I do a Sunday show anyway, so it'll probably be Sunday. But I will, as soon as I can confirm and we got our thumbnail ready, you'll see everything go upload and you can check it out. But besides that, everybody, I want to thank you again. Let's do this real soon. I appreciate you all. And until next time, everybody, grace and peace. Take care.